All right, thank you all for coming. I want to welcome you here to this event, Marriage at the Supreme Court, a debate on the upcoming cases. My name is Mike Havlick. I'm the current president of the Federalist Society here at CU Law. Co-sponsoring this event alongside the Federalist Society is the American Constitution Society, as well as the Bryan R. White Center for the Studies of American Constitutional Law. And it should be noted that the Bryan White Center has graciously offered to fund the after-party reception, which everyone that has RSVP'd to the event is invited to afterwards, just in Betcher Hall, right alongside this room. In January of this year, the Supreme Court agreed to hear 4 new cases to decide whether the U.S. Constitution guarantees all Americans the right to enter into same-sex marriages. To arrive at its forthcoming decision, the court will likely rule on whether the 50 states have the power to ban same-sex marriages, or else whether the states may refuse to recognize such marriages performed in another state. As of now, same-sex marriages are allowed in 36 states, with bans remaining in the other 14, but all are under court challenge. Recently, the Ninth Circuit Court of Appeals, in a split decision, called this an important and highly controversial question, currently a matter of great debate in our nation and an issue over which people of goodwill may disagree, sometimes strongly. Before you today are 2 very qualified and articulate persons who disagree. Many of us also in this room disagree, and sometimes even strongly. The Supreme Court has not issued its opinion, and so as we wait, I ask that you act professionally tonight, listen carefully, and have an open mind to what these 2 scholars have to say. Closest to me is a person that many of you know and love, Professor Melissa Hart. Professor Hart devotes her teaching and scholarship to employment discrimination, civil procedure, and constitutional law. She's been teaching at the University of Colorado Law School since 2000 and has been the director of the Bryan R. White Center for the Study of American Constitutional Law since 2010. She graduated from Harvard Law School in 1995 and went on to clerk for Judge Guido Calabresi of the Second Circuit and for Justice John Paul Stevens of the United States Supreme Court. Professor Hart practiced law for several years in Washington, D.C., including as a trial attorney for the U.S. Department of Justice. Professor Hart runs the Colorado Law School chapter of the Marshall Brennan Constitutional Literacy Project. She remains active in the legal community, serving on the Colorado Access to Justice Commission, the Colorado Supreme Court's Judicial Ethics Advisory Committee, and Board of Continuing Judicial and Legal Education. She was the 2012 president of the American Association of Law Schools section on civil rights. On my far left, we have Dr. Ryan Anderson. Dr. Anderson received his Bachelor's of Arts degree from Princeton University, graduating magna cum laude. He earned his doctoral degree in political philosophy from the University of Notre Dame, where he received his master's degree as well. Dr. Anderson researches and writes about marriage and religious liberties at the Heritage Foundation. Dr. Anderson's recent work at Heritage focuses on the constitutional questions surrounding same-sex marriage. He's the co-author of the acclaimed book, What is Marriage? Man and Woman, A Defense. Justice Samuel Alito cited the book twice in his dissenting opinion in the Supreme Court case involving the Defense of Marriage Act. Dr. Anderson has debated the legal definition of marriage on CNN's Piers Morgan Live. It's a YouTube video that I highly recommend looking up, and also has made appearances on MSNBC and Fox News. His work has been featured in major newspapers such as the New York Times, the Washington Post, the Wall Street Journal, and others. The structure of this debate, by mutual agreement, will be first 20-minute opening remarks from each side, followed by a 5-minute rebuttal. After that, we'll open it up to audience questions, and as is tradition here at CU Law School, students have priority in asking a few questions before we open it up to the greater audience. So without further ado, I know you guys didn't come here to listen to me speak. Dr. Anderson, you will start.
Thank you. Thank you for being here, and thank you for that kind introduction. I'm doing 2 talks today at Boulder. This one on some of the constitutional issues, and then tonight at 7 o'clock in the engineering building, I'm giving a lecture philosophical lecture about what marriage is. This will be the easier of my two presentations because this afternoon I don't have to argue that my view about marriage is the truth. That's going to be my argument for tonight. My argument right now is simply that my definition of marriage is allowed by the US Constitution. That's the question before the US Supreme Court. It's not whether my preferred marriage policy is the best, but only whether it's allowed by the Constitution. It's not whether government-recognized same-sex marriage is good or bad public policy, only whether it's required by the Constitution. So my opponent this afternoon will have to prove that the marriage policy that has existed in the United States throughout our entire history, up until a decade ago, is violating the US Constitution. And the only way I'm going to argue that my opponent can argue that is to adopt a view of marriage that sees it as essentially a genderless institution and then argue that the Constitution requires that vision of marriage. The Constitution requires the states to redefine marriage in such a way. I'm going to argue that equal protection alone isn't enough, that to strike down these state marriage laws, you have to say that the vision of marriage that our law has long applied equally is simply wrong, and that our Constitution requires a different vision of what marriage is. But I'll argue that our Constitution is silent on what marriage is and on what policy goals the states should design it to serve. I'll argue there are good policy arguments on both sides of this debate, and therefore judges should not insert their own policy preferences about marriage and then declare them to be required by the Constitution. At the end of the day, this is the debate about whether citizens or judges will determine the future of marriage policy in this country. So to give just a brief outline, I'm going to argue first that the Supreme Court's Windsor decision not only doesn't require the redefinition of marriage, but that it actually upholds the state constitutional authority to make marriage policy. I'll then argue that the 14th Amendment doesn't require the redefinition of marriage in neither the Due Process Clause nor the Equal Protection Clause. So let me start with Windsor. Windsor supports the authority of states to define marriage. Every single time that Windsor talks about the constitutional harm of the Federal Defense of Marriage Act, it mentions the fact that the state had chosen to recognize the bond that the feds were choosing to exclude. Every single time, it's the states having recognized a relationship that is highlighted. Justice Kennedy expressly said that it was the deviation from the default deference to state definitions that drove his opinion. Kennedy writes, quote, "The significance of state responsibilities for the definition and regulation of marriage dates to the nation's beginning." United States District Judge Juan Perez Gimenez, a Democrat appointee by Jimmy Carter, when he upheld the male-female definition of marriage in Puerto Rico, this is what he wrote, quote, "The Windsor opinion did not create a fundamental right to same-gender marriage, nor did it establish that state opposite-gender marriage regulations are amenable to federal constitutional challenges. If anything, Windsor stands for the opposite proposition. It reaffirms the state authority over marriage, buttressing Baker's conclusion that marriage is simply not a federal question," end quote. Judge Perez Gimenez then concludes, quote, "It takes inexplicable contortions of the mind or perhaps even willful ignorance. This court does not venture an answer here to interpret Windsor's endorsement of the state control of marriage as eliminating the state control of marriage," end quote. So I don't think my opponent will be able to successfully appeal to the authority of Windsor. So if not Windsor, then it must be something in the 14th Amendment. But as the Sixth Circuit Court recently pointed out, all sides of this debate agree that the original meaning of the 14th Amendment does not require the redefinition of marriage. The Sixth Circuit held, quote, "Nobody argues that the people who adopted the 14th Amendment understood it to require the states to change the definition of marriage." The Sixth Circuit continued, "From the founding of the Republic to 2003, every state defined marriage as a relationship between a man and a woman, meaning that the 14th Amendment permits, though it does not require, states to define marriage in that way," end quote. The opinion then closed by noting, "Not a single U.S. Supreme Court justice in American history has written an opinion maintaining that the traditional definition of marriage violates the 14th Amendment," end quote. So I don't think my opponent can successfully appeal to the original meaning of the 14th Amendment. So if not the 14th Amendment, perhaps it's something in the Supreme Court's jurisprudence surrounding the 14th Amendment. Let's start with fundamental rights under the Due Process Clause. As the Supreme Court held in Glucksberg, fundamental rights are, quote, deeply rooted in this nation's history and tradition, and, quote, implicit in the concept of ordered liberty, such that, quote, neither liberty nor justice would exist if they were sacrificed. Clearly, a right to marry someone of the same sex does not fit that description. As the Supreme Court explained in its Windsor decision, including same-sex couples in marriage is, quote, a new perspective, a new insight, end quote, not deeply rooted in our nation's history or tradition. Same-sex civil marriage isn't deeply rooted in the nation's history and tradition, and thus, whatever its policy merits, it cannot be considered a fundamental right under Due Process Clause jurisprudence. Windsor, in fact, explained, quote, until recent years, marriage between a man and a woman had been thought of by most people as essential to the very definition of that term and to its role and function throughout the history of civilization, end quote. Indeed, whenever the Supreme Court has recognized marriage as a fundamental right, it has always defined marriage as the union of a man and a woman, and it's always explained the rationale for why marriage is a fundamental right in terms of the procreative social ordering aspects of male-female marriage. So I don't think an appeal to fundamental rights under Glucksberg will be very successful. Nor do I think appeals to interracial marriage will provide much help. As Judge Niemeyer explains, Loving v. Virginia stood for, quote, or in Loving v. Virginia, the couple that was asserting a right was, quote, asserting a right to enter into a traditional marriage of the type that has been recognized since the beginning of the nation, a union between one man and one woman. Judge Niemeyer then concluded, Loving simply held that race, which is completely unrelated to the institution of marriage, could not be the basis of marital restrictions. To stretch Loving's holding to say that the right to marry is not limited by gender is to ignore the inextricable biological link between marriage and procreation that the Supreme Court has always recognized, end quote. So I don't think Loving or appeals to interracial marriage will help. Before I move to equal protection, let me say one more thing about the due process jurisprudence here. I don't know if there is a limiting principle, because the court has ruled that entering into and having the government recognize your marriage, understood as the union of husband and wife, is a fundamental right. But if the right is to be redefined and to be understood simply as the committed caregiving relationship of one's choice, where does that logic lead? Indeed, Justice Sotomayor asked Ted Olson this exact question during oral arguments on Prop 8. She said, if marriage is understood as marriage as a fundamental right is understood as simply consenting adult caregiving, quote, what state restrictions could ever exist? For example, with respect to the number of people that could get married, end quote. The Sixth Circuit saw Sotomayor's logic, and this is what they said in their opinion. Of the plaintiffs suing to redefine marriage, quote, their definition does too little because it fails to account for plural marriages where there is no reason to think that 3 or 4 adults, whether gay, bisexual, or straight, lack the capacity to share love, affection, and commitment, or for that matter, the capacity to be capable and more plentiful parents to boot, end quote. So the Sixth Circuit concluded, quote, if it is constitutionally irrational to stand by the man-woman definition of marriage, it must be constitutionally irrational to stand by the monogamous definition of marriage. Plaintiffs have no answer to that point, end quote. So that's why I think an appeal to fundamental rights under the Due Process Clause won't help. Let me turn to the Equal Protection Clause. And let's start with animus. I think anyone with passing familiarity with the history of marriage knows that the institution itself did not arise because of animus towards gays and lesbians. Indeed, ancient thinkers in Greece and Rome, with no contact with Judeo-Christian teaching, and ancient Greek and Roman political societies affirmed that marriage is a male-female union, even as they embraced same-sex sexual relationships. The same is true of societies that had no idea of gay people as a class. So you can't say that the male-female marriage definition arose simply out of animus towards gays and lesbians when the history of the marital institution arose even in societies that embraced same-sex sexual relationships. The Sixth Circuit acknowledged this point. They pointed out that gays and lesbians have undoubtedly suffered discrimination, but they argued that the marital institution isn't part of that history of discrimination. So the court writes, "We also cannot deny that the institution of marriage arose independently of this record of discrimination. The traditional definition of marriage goes back thousands of years and spans almost every society in history. By contrast, quote, American laws targeting same-sex couples did not develop until the last third of the 20th century. Double end quote. So the internal quote was the Sixth Circuit Court quoting Lawrence. What happened in the Lawrence decision? Lawrence struck down some of those laws that had prohibited sex between persons of the same sex. It did not, and it does not, require the redefinition of marriage. Laws that banned homosexual sodomy are radically different from laws that define marriage as the union of husband and wife. And the Supreme Court, in its Lawrence decision, found that the former, the sodomy laws, infringed on a privacy right, while the latter specify which unions will be eligible for public recognition. A right to privacy is a right to be left alone by the government, not a right to have the government recognize the relationship of one's choice. So I don't think an appeal to animus can be successful. So let me go to protected class. The Supreme Court, including in its Windsor decision, has never applied heightened scrutiny based on sexual orientation, never claimed sexual orientation as a suspect class, and I don't think it should. But even if you were to argue that sexual orientation should be protected class under equal protection jurisprudence, one would have to argue that sexual orientation, quote, creates a class which exhibits obvious, immutable, or distinguishing characteristics that define them as a discrete group. But the American Psychological Association describes sexual orientation as, quote, a range of behaviors and attractions, end quote, and reports, quote, sexual orientation ranges along a continuum. The APA also points out that in the question of why particular orientations develop, quote, there is no consensus among scientists. These APA findings, I argue, fatally undermine the idea that sexual orientation describes a discrete class for suspect class purposes. Furthermore, to be a protected class under equal protection jurisprudence, a group has to be, quote, politically powerless in the sense that they have no ability to attract the attention of lawmakers. But as Chief Justice Roberts pointed out during oral arguments, quote, political figures are falling over themselves to support gay marriage. Indeed, support for same-sex marriage and for LGBT non-discrimination laws have been embraced by the President of the United States and the Democratic Party platform. It's hard to say gays and lesbians are politically powerless, so it'll be impossible to argue that they're a suspect class. So perhaps there's simply no rational basis to marriage law. Here I want to consider the social function that marriage plays. From a policy perspective, marriage is about attaching a man and a woman to each other as husband and wife to then be father and mother to any children that their sexual union may produce. Whenever a child is born, there is always a mother close by. That's a simple fact of biology. The question for culture, and therefore the question for law, is will a father be close by, and if so, for how long? Marriage is the institution that societies all across the globe and all throughout human history devised to maximize the likelihood that that man commits to that woman, and then the two of them committed to each other take responsibility for that child. So understood, marriage is based on an anthropological truth that men and women are distinct and complementary. It's based on a biological fact that reproduction requires both a man and a woman. It's based on a social reality that children deserve a mother and a father. Even President Obama admits this aspect about marriage and the importance of fathers. Consider this quote. We know the statistics. Children who grow up without a father are 5 times more likely to live in poverty and commit crime, 9 times more likely to drop out of school, and 20 times more likely to end up in prison. They are more likely to have behavioral problems or run away from home or become teenage parents themselves. And the foundations of our community are weaker because of it, end quote. Fathers matter, and marriage helps connect fathers to mothers to children. But you don't have to think that my marriage policy is ideal to think that it's constitutionally permissible. For an equal protection challenge to succeed, this argument about the public policy purpose of marriage would have to be proved to have no rational basis. But universal human experience up until 15 years ago shows the rational basis, the rational foundations of such a marriage policy. So if not rational basis, we would have to argue whether or not it passes a higher level of scrutiny, whether it's, let's just go with strict scrutiny here. So even if you implausibly, on my account, were to argue that sexual orientation is a suspect class, that gays and lesbians are politically powerless, that they're a discrete group, and therefore we have to have a heightened level of scrutiny, I argue that the man-woman definition of marriage still passes, because marriage laws shape the institution for everyone. And that institution can only fulfill its social purpose when defined correctly. And because a strong marriage culture is a compelling interest, because it affects every other state interest, defining marriage as the permanent and exclusive union of a husband and a wife is a narrowly tailored, indeed a perfectly tailored means of achieving that end. Marriage plays a fundamental role in society by encouraging men and women to commit permanently and exclusively to each other. They work by embodying a vision of marriage that can justify those marital norms. There's nothing magical about the word marriage. It's not the legal title or the word that encourages men and women to commit and to live out those marital norms of monogamy, exclusivity, and permanency. What does the work is the social reality of marriage and the intelligibility of its norms. These help to channel behavior. What we know is that the law shapes culture, our culture shapes our beliefs, and then our beliefs shape our actions. The law is a teacher, and it will shape not just a handful of marriages, but all marriages by shaping the public understanding of what marriage is. And if you doubt this, simply consider the impact of no-fault divorce. With no-fault divorce, we went from a regime in which marriage had an expectation of being a permanent union, where you would file for divorce by citing fault. In the common law, it was the 3 A's of abuse, abandonment, and adultery, to a system in which you could file for divorce without citing grounds for divorce and without your partner's consent. In the years after the introduction of no-fault divorce, we saw divorce rates more than double. Now, part of that change came from the culture itself. Part of that change came from the 60s, but part of that change came from what the law was teaching about marriage, that it need not even aspire to be a permanent union, that you could get out of your marriage for frivolous reasons. So if the law redefines marriage now to say the male-female aspect is arbitrary, to say that marriage is simply about consenting adult love of whatever size or shape the consent comes in, what is the principled basis for retaining monogamy, exclusivity, or the expectation of permanency? If the law teaches a falsehood about marriage, it would make it harder for people to live out the norms of marriage, because the norms make no sense as a matter of principle if marriage is simply about consenting adult caregiving. Since I have a minute left, I'll skip to the end. A state can either preserve the benefits of the man-woman definition of marriage, or it can remove that definition, replacing it with an alternative, and risk losing those benefits. It cannot do both. Thus, a state's choice to preserve the man-woman definition of marriage is narrowly tailored, indeed perfectly tailored, to its interest in preserving those benefits. So in conclusion, there's nothing in the US Constitution that requires all 50 states to redefine marriage. Part of the beauty of federalism is that experimentation can take place in the states. As the Sixth Circuit held in its ruling, quote, "Federalism permits laboratories of experimentation, accent on the plural, allowing one state to innovate one way, another state another, and a third state to assess the trial and error over time." To make a case to the contrary, my opponent would can't appeal to the authority of Windsor, or the text and the original meaning of the 14th Amendment, or to fundamental rights under the Due Process Clause, to Loving v. Virginia, or to equal protection. She can't claim that gays and lesbians are politically powerless, so she can't say they're a suspect class. Nor do I think you can argue that there's no rational basis to marriage, or that they're not perfectly tailored. Thank you.
Thank you for having me here. My opponent, Mr. Anderson, does this all the time. I do not. So I may not be as fluent or fluid as he was, but I will say that what I'm going to do is I'm going to appeal to Windsor and to the meaning and text of the Equal Protection Clause and to fundamental rights under the 14th Amendment and to the idea that gays are in fact entitled to heightened scrutiny and to the idea that the justifications for marriage can't withstand rational basis review in responding to his arguments. I can do that, and I am doing that. So just to clarify. So one of the things I actually want to say before I start talking about the merits of the question is one of the things that struck me in organizing this with the American Constitution Society and the Federalist Society is that for me, as the director of the Byron White Center, it's really important to try to frame things in relatively neutral terms in terms of advertising, and then try to present the best arguments on both sides of a debate. I think that's the best way to have a good conversation about it. And right at the beginning of talking about how to do that, one of the things we ran across was a real challenge in titling this event, because the way we frame this issue starts with what we call it. Do we call it redefining marriage, or do we call it marriage equality? Which one of those two things is it? Because those are very different things. And I think fundamentally, that's what's at stake here, is an understanding of what we mean, what we think we're doing when we talk about what I call marriage equality, but what I recognize other people see as redefining marriage. As you probably all know, and as Mike noted in his introduction, DeBoer against Snyder and the companion cases that are going to be argued before the court in April raise two distinct questions. One is whether states are required to recognize marriages validly entered into in other states. You don't hear a lot of debate about that. I think most people think that that prong of the argument is likely to come out in favor of a requirement to recognize that the logic of Windsor, both in its federalism tones and in its liberty tones, would support that. So what the debate really is about is whether banning same-sex marriage is unconstitutional, whether states, in fact, are required to recognize same-sex marriage. And this latter one really requires the court to consider and requires us to consider whether states can deny to gay and lesbian couples, which is more than 700,000 families, including nearly 220,000 children in this country, equal participation in an institution that the court nearly 50 years ago in Loving against Virginia recognized as giving legal expression to, quote, one of the vital personal rights essential to the orderly pursuit of happiness. I believe that the Constitution does require that. And I'll say something briefly about Windsor. I actually am not going to focus much on Windsor, but one of the things that is confusing about Windsor, there's a lot that's confusing about Windsor, but one of the things that's most confusing about it, its sort of central problem, is that it's a decision that goes back and forth between whether it's going to be a federalism decision, is this about the states' rights, or a liberty and dignity decision, is this actually about individual liberty and dignity. And Mr. Anderson read a bit from Windsor that talked about the states' rights aspects. That's definitely there. That's definitely something that the court will likely have to address. As I mentioned, I think it will go more to the recognition part of this debate. But here's some other quotes from Windsor. So Windsor reasoned that the affected same-sex couples in the case had their lives burdened in visible and public ways by DOMA's denial of marriage recognition. By barring application of all of these federal statutes that turned on marriage, Section 3 wrote inequality into the entire United States Code, brought financial harm to the children of same-sex couples, divested such couples of the duties and responsibilities that are an essential part of married life and that they in most cases would be honored to accept. On a more personal level, the court explained, DOMA placed same-sex couples in an unstable position of being in a second-tier marriage, demeaned those couples, and humiliated the tens of thousands of children being raised by such couples. It instructed all persons with whom same-sex couples interact, including their own children, that their marriage is less worthy than the marriages of others. So that view about the value of marriages between same-sex couples is also a dominant part of Windsor. Which one of those views that Justice Kennedy is going to take is, of course, basically what's at stake in this case. And as with almost everything these days, it seems everybody's pitching their arguments to Justice Kennedy. Are we going to, which is he going to be more states' rights or more liberty that day? I think the arguments for the 14th Amendment's invalidation of these bans on same-sex marriage are very strong, and the court actually has a couple of different ways it could go in coming out that way. And I want to give you an example of what we're talking about when we're talking about bans on same-sex marriage. In 1998, not in 1 AD, but in 1998, the voters of the state of Michigan, by popular vote, added a provision to their state constitution that says that to secure and preserve the benefits of marriage for our society and for future generations of children, the union of one man and one woman in marriage shall be the only agreement recognized as marriage or similar union for any purpose. So Michigan's constitutional provision does both. It both refuses recognition of marriage from other states and also denies same-sex couples in Michigan the right to marry. This was one of many such laws passed around the United States between 1998 and 2012. Most of the bans that we're talking about were enacted during that 14-year period as part of an orchestrated national campaign carried around the states. And I'm going to come back to the animus question in connection with that in a few minutes, but I first want to talk about, so Mr. Anderson has sort of set out the different ways that the court could approach this case. It could focus on the fundamental right to marry from Loving against Virginia. I don't think that's what the court's going to do, so I'm not going to spend too much time on that, but I do just want to say one thing about whether the court could do that, what it was that Loving recognized. So Mr. Anderson says that all that Loving recognized was the traditional marriage of the type that had been traditionally recognized in this country. Actually, blacks and whites had not been permitted to marry in many states in this country traditionally. So it didn't recognize the traditional version of marriage. It said that, in fact, marriage couldn't exclude black and white couples from marrying. And what it focused on was the fundamental right to choose a person of your choice. It is true that Mr. and Mrs. Loving were a man and a woman. So to that extent, it wasn't confronted with the question, would this apply also to same-sex marriage? But again, I don't really think that the fundamental right to marry is going to be the primary focus of the court's decision. I think it's going to focus on equal protection, although I will say that because we're talking about a law that burdens this fundamental right to marry, I do think that the state's obligation to justify its laws, to come up with a reason for its laws, will end up being viewed by the court as more significant. It's not a small thing that's being burdened here. It's a huge thing that's being burdened here. So I think the court will focus on the classification hierarchy embodied in equal protection jurisprudence. And I think it's most likely that what the court will do is focus on the arguments that are being pressed by a lot of parties, including the United States Solicitor General submitted an amicus brief arguing that the right way for the court to look at this is to say that gays and lesbians are subject to heightened scrutiny under the Equal Protection Clause. And one of the things that the United States brief recognizes, that I think a lot of people recognize, is that although it's true that in Windsor and in Lawrence against Texas and in Romer against Evans, the case that struck down our own hate law, the court has not articulated clearly what standard it's using. It has been applying a heightened scrutiny. People can call it rational basis plus or rational basis with bite, but it has been applying something more than rational basis review to these laws. That being the case, I think this is a good opportunity that the court should take to just say that. Stop hiding the ball on what standard of review it's using and acknowledge that it's applying heightened scrutiny. Now, there are four tests or four factors, thank you, that the court will look at whether sexual orientation as a classification meets before deciding whether to apply heightened scrutiny. First, those seeking that protection must show a history of discrimination against their group. They have to show that sexual orientation has nothing to do with their ability to take full part in society. They have to show that sexual orientation is a part of their inherent identity, or is an immutable characteristic is the word that is often used. And they have to show that they are a specific group that has limited political power in seeking to promote its aims. Gays and lesbians do satisfy all four of those factors. First, gays and lesbians clearly have suffered a history of purposeful discrimination, and not just a history of purposeful discrimination. There is still current and constant discrimination. Many states criminalized homosexual conduct for many years. That was the subject of ultimately Lawrence against Texas. Gays and lesbians have been ostracized, humiliated, denied private and government employment, denied the right to form a family, denied the right to adopt, of course, denied the right to marry. In many states, discrimination against gays and lesbians in the workplace is still legally permissible. And if you look at what's happened in the past 2 decades, and a number of laws that actually had provided protection to gays and lesbians have been repealed in many states. So again, there is clearly a history of discrimination, but it's more than just a history. It's really a current problem in our society. Sexual orientation is clearly irrelevant to a person's ability to take full part in society. I don't imagine anyone pausing much over that piece of the argument. As to whether homosexuality or sexual orientation is an immutable characteristic, sexual orientation it's fundamental to a person's identity, and it's not changeable. So it's immutable in the sense of not being changeable. Mr. Anderson talks about the reality that psychologists have recognized that sexual orientation runs along a spectrum. There's not an on-off switch, or there are many on-off switches for sexual orientation. That does not make it not an immutable characteristic. There's been a lot of discussion recently about how race runs along a spectrum. There are many people now prefer to characterize themselves as multiracial rather than picking whether they are black or white or Latino. That's the spectral nature of a classification does not make it not a classification that we can subject to heightened scrutiny. That argument just doesn't make sense. And then as to the political powerlessness thing, there have been some recent successes on behalf of gays and lesbians. That is certainly true. And yet if we look at the number of states that passed state-level Defense of Marriage Act amendments to their constitution between 1998 and 2012, if we look at the rash of state-level religious freedom restoration acts that are being passed around the country in an effort to permit discrimination against people on the basis of sexual orientation for religious reasons, if we look at the number of states that still permit discrimination on the basis of sexual orientation, despite repeated attempts to enact state-level protections against discrimination. If we look at the fact that the Employee Non-Discrimination Act, which would add sexual orientation as an employment protection into federal law, has come up repeatedly and has never been able to make it to a successful vote in Congress. The notion that gays and lesbians have this great political power simply is false. They are in fact powerless to protect themselves as a group through the political process in precisely the same ways that other protected classes are. Furthermore, that political powerless prong, I think although it's clearly part of the doctrine, the court says it whenever they're talking about heightened scrutiny, if you think about cases like Frontiero against Richardson, which is a case of applying heightened scrutiny to the classification of women. That case was decided right in the middle of the women's movement. No question that women had become more politically powerful in the early 1970s than we had ever been in this nation's history. And yet the court recognized that although we had political power in the popular culture at that time, we were politically powerless in the sense that the Constitution recognizes. So the idea that you have to somehow have no ability to get any laws passed is not what the court's talking about in talking about heightened scrutiny. So I think that there's a great argument for applying heightened scrutiny, and I hope that that's what the court will do. And if heightened scrutiny is applied, what heightened scrutiny requires, it's this sort of mid-level, so it's not the strict scrutiny that Mr. Anderson was talking about. I don't see anyone arguing that, and I don't think that's what the court would do. Strict scrutiny is really reserved for race and national origin classification. So that's not going to happen. And again, I don't see anyone arguing that it should. But heightened scrutiny requires that a law that draws distinctions like these bans on same-sex marriage do must have terms that are substantially related to an important governmental objective. Marriage bans will not meet that standard. If the heightened scrutiny standard is applied, they will not meet that standard. So let's look at the rationales that are offered for them. So the Sixth Circuit, Jeff Sutton in the Sixth Circuit, he relied on two things: a state interest in creating an incentive for two people who procreate together to stay together for purposes of rearing offspring. So he was concerned, as many people talk about it, about irresponsible procreation. We need to have marriage between a man and a woman so that we aren't all running around having sex and having babies out of wedlock. This way, we will have babies in wedlock. There's no requirement when you get married that you say you're planning to procreate. There's no requirement when you get married that you be physically capable of procreating. The states allow old people to get married. States allow sterile people to get married. The notion that somehow what marriage is about being sure that there's not irresponsible procreation going on seems to me to diminish very much what it is that states are doing with marriage laws. And in fact, if you look historically and traditionally, states have done all kinds of things with marriage laws. Marriage laws have been used to encourage, obviously to encourage stability. They are used to push all kinds of social policies about how we understand poor people and who we think of as irresponsible and responsible. As historically, if you look at the marriage laws in the late 19th and early 20th century, a lot of them were used not so much to focus on the marriage itself, but to focus on who we see as good and bad in our society. Marriage laws have also changed over time. So the notion that there's this traditional marriage that has existed forever is not true. It used to be the case under the law of coverture, for example, that a woman was considered essentially the property of her husband. That's not true anymore, even though that was a traditional part of marriage. So marriage evolving is a normal part of how states and societies define marriage. In fact, if you look at the years between 1998 and 2012, this whole raft of states redefined their marriage laws to say marriage can only ever be between a man and a woman. That would be a good example of marriage laws being defined in a new, specific way. So that notion of that's what marriage is for, I think, is problematic. The Sixth Circuit also relied on a state interest in taking a wait-and-see approach and having this issue resolved by the states. I think the fact that so many states put marriage bans into their constitutions really underscores the problem with the notion that states are taking a wait-and-see approach. What actually happened between 1998 and 2012 is that state constitutions were amended so that they couldn't take a wait-and-see approach. They made a decision, and nothing is going to change that. It is hard to change a state constitution. Once something, it's not, unfortunately, that hard to get things in there, but once something is in there, it is hard to get it out. So there's not a wait-and-see approach that's being taken. That's just false. The other arguments that have been pushed but have been sort of abandoned now, I think the respondents are pretty focused on those two arguments now. But the other arguments that are pushed are that marriage bans apply equally to gay men and lesbian women, so there's not a sex discrimination problem there, and that same-sex marriage harms families, children, and society. So I want to come back, and I realize I've talked for too long on that issue. I want to come back, though, to animus and to the rational basis review possibility. So in a really well-done amicus brief submitted to the Supreme Court, Federalist Society founder Stephen Calabresi was among a number of people who said, in fact, it is clear that the meaning of the 14th Amendment, not understandings, when we focus on, well, what did the people who passed the 14th Amendment understand that it would apply to require same-sex marriage? No, they certainly didn't, nor did they understand that it would apply to anything that had to do with a car or a phone. If you focus on what they understood, you will always have a problem with application today. But if you focus on the meaning of the provision. The meaning of the Equal Protection Clause was to prevent laws that create the caste laws, essentially. Laws that is distinguished against people based on class and created pariahs of certain people in society. And that was the focus of the framers of the 14th Amendment. And again, in this really nicely done brief, Calabresi and his co-amici set out a great deal of historical information about the understanding at that time, and again, I try not to use the word understanding, but the meaning at that time of the laws that they were passing, what they thought they were doing with the Equal Protection Clause. And it's very powerful. And I just want to close with the question of animus. And my notes are all messed up. I need to have a machine like that, not pieces of paper. I'm very old-fashioned. So just a little bit about animus. A few weeks before Ohioans voted on their DOMA, the Columbus Dispatch reported that Ohio's Secretary of State was standing by remarks he had made comparing same-sex couples with barnyard animals. A post-election analysis of media messages of Prop 8, the California ban, concluded that anti-gay forces know how to exploit and stimulate anti-gay prejudice. And I have more, but I'm going to stop. But the evidence of animus behind these bans on gay marriage is extensive. And so if the question is whether there's animus there, the answer is clearly yes. But the court doesn't have to go there to find that these marriage bans violate the 14th Amendment. Thank you.
That was excellent. Lots to discuss. I only have 5 minutes, so I'm going to try to make 5 points in response in my 5 minutes, starting with marriage bans, because Professor Hart opened by saying how difficult it is to use accurate language. I want to point out that none of the states banned same-sex marriage, and that's different than interracial marriage. Interracial marriage was truly banned. You could go to jail if you were in an interracial marriage. No one who gets gay married could go to jail in any of the 50 states. What we're talking about, and I think this is important because the rhetoric of so-and-so state voted to ban same-sex marriage looks like it infringes on liberty. Mayor Bloomberg tried to ban large sugary soft drinks in New York City. It would be illegal for you to try to purchase a large Big Gulp in New York City. All that's at stake here is the definition of marriage for public policy. What these laws did was defined what the institution of marriage is for public policy. They didn't ban anything. By comparison, in Loving v. Virginia, the Virginia statute would have sent that couple to jail. Interracial marriage was truly banned in the United States. If you were in a common law interracial marriage, you were committing a crime. If you get gay married in any of the 50 states at your local church, and if you live together and love each other, you have a liberty right to do that. So I think it's a little false to frame it in terms of a ban and in terms of liberty. What we're talking about is the definition. What is the definition of the public institution of marriage for public law? That brings up the interracial marriage example, which is my second point, and to say that throughout all of human history, every great thinker who has ever written about marriage, you never see a discussion of race. Whether it's Plato, Aristotle, and Cicero, whether it's the Jews, Christians, and Muslims, whether it's Augustine, Aquinas, Luther, Calvin, John Locke, Immanuel Kant, Mahatma Gandhi. None of them talk about skin color. None of them talk about race. Each and every one of them talks about sexual complementarity. Each and every one of them says that the heart of what marriage is a union of a man and a woman, a husband and a wife, a mother and a father. None of them talked about race. When the U.S. colonies banned interracial marriage, they were the first political communities in the history of the world to do so. And the reason they did so wasn't because of anything about marriage. They did this because they were racist, and they wanted to prop up a racist regime of slavery. If you have a race-based regime of slavery, you need to keep the races separate so you don't have interracial children. So what they did was they redefined marriage from its historic and common law definition. So marriage in common law in Great Britain did not entail any racial component. They redefined marriage to place a ban on interracial marriage. What Loving v. Virginia did was restored the historic understanding of what marriage is. It pointed out that skin color is irrelevant to marriage. And the rationale for Loving was that marriage laws had to be colorblind precisely because they can't be gender blind. So I just think the history of that particular debate cuts in the exact opposite direction. Point three, I want to talk a little bit about the heightened scrutiny. And I have to admit that earlier this week I testified before the U.S. Commission on Civil Rights against the Employment Non-Discrimination Act. So we probably disagree about that. In addition to citing the American Psychological Association, I cited the chair of psychiatry at Johns Hopkins University Medical School and Hospital, pointing out that it's neither a discrete nor immutable characteristic, and that it's unlike race. The gist of my remarks was how sexual orientation and gender identity are unlike race and therefore shouldn't be a protected class. One of the things that I mentioned, and I need to pull this up to read the exact quote, was to ask a simple question of what would the limiting principle be if you do elevate sexual orientation. Wesleyan College has extended the LGBT acronym and created a safe space on campus for LGBTQQFAGPBBDSM. It stands for lesbian, gay, bisexual, transgender, transsexual, queer, questioning, flexual, asexual, gender fuck, polyamorous, bondage, discipline, dominance, submission, sadism, masochism. If you elevate sexual orientation to a protected class under the law, which sexual orientations are included? Where do you stop the LGBT acronym? And what is your principle for stopping it? That was point 3, and just to add on that, political powerlessness does not mean that you always win. It just means that you have a fighting chance. And when you have the President of the United States and an entire platform of a political party, and ENDA has passed in the Senate, so it's passed in one of the 2 legislative chambers, it's very hard to argue that you're politically powerless. Politically powerless doesn't mean that you have no power, nor does it mean that you have power to always win. It means you're somewhere in between. And it's clear that in this case, they're not politically powerless. I just want to mention Windsor. All of the quotes that Professor Hart read are entirely accurate, but each and every one depended on a state that had defined marriage to include same-sex couples. Each and every quote she read talked about the federal government refusing to recognize the marriage of the same-sex couple. Not the relationship of the same-sex couple, but a relationship that had been recognized as a marriage. In closing, I'll just say what I found most interesting is that not once in the 20-minute presentation did we hear an explanation of what marriage is. The reason that I titled the book that I co-authored, the reason that I titled the law review article that I wrote, What is Marriage? That's the question that lies at the basis of this entire debate. Everyone in this room is in favor of marriage equality. We all want the laws to treat all marriages equally. What we disagree about is what is a marriage? And only if you can answer that question, if you know what the reality is about marriage, can you then say whether or not any given marriage policy is denying equality. But if you do, so this is the question I'll close with, if you do sue for marriage equality for the same-sex couple, on what basis do you deny marriage equality for the same-sex throuple?
I'm not even intend to bring my notes up here. I have no idea where they are. So another interesting example of the struggles we have with language, I don't think there's any such thing as getting gay married. I actually think it's just getting married. And I think that it's an interesting way that the terminology cuts towards or against people. So I think that marriage is a right to choose a person that you want to be with and have a legally recognized relationship. The consequences, we can say that there's a difference between these constitutional amendments that define marriage as a man and a woman and bans on interracial marriage that subjected the couple to criminal liability. And certainly I think that's right, that the criminalization of a relationship is different in lots of ways, and it is different. That's part of why it's so striking that it's only been recently that it's been clear that it was unconstitutional to criminalize a same-sex relationship. So that I think is definitely right. I think that whether the consequences of defining marriage in that particular way for the couples whose marriages are not recognized, consequences that go to their right to have families that include children that they have legal authority over, consequences that include, there are tax consequences, there are benefits consequences, there are job consequences. We are obviously very interested in the linguistic differences, but to people living under those regimes, that is a ban on their marriage. And that is what it feels like, and that is what I believe it is intended to feel like. It is saying you can never choose the person that you want to spend the rest of your life with and have them legally recognized have that legally recognized in a civil marriage. Is there a slippery slope from gay marriage to to polygamy. And that is definitely one of the arguments that always forms a part of this debate. I think that it certainly could be the case that people, actually it's not could be the case, it will be the case that people will come out and start making arguments that polygamy also should be recognized. And when those arguments are made, we will have to grapple with the question, are the state justifications for recognizing a marriage as being between just two people rather than multiple people sufficient to permit that kind of distinction? There are very different state justifications that would go to preventing marriage from being among multiple people. They have to do with administrative questions. When you have legal rights such as rules about who inherits property, when you have the administration of tax systems and benefit systems that rely on having one primary beneficiary, the idea of multiple marriages is much more complicated than the idea of gay marriage. There are also questions about consent. There are questions about I think those are the two primary ones. But that's not the question that's before us right now. The question that's before us right now is, are the state justifications for refusing to permit same-sex couples to choose who they have civil marriage with? And we're not talking at all, obviously, about the religious marriage. We're talking about civil marriage. That question, I think, is the answer to that question is clearly no. There just is no sufficient state justification to warrant excluding 700,000 families, 220,000 children from the legal protections that come with the recognition of a civil marriage.
So thank you very much for that insightful debate. We're going to open it up to questions now, and as I stated at the onset, if there's any students with questions, we'll go to the students first and then open it up for others. As well as I would say, if you guys have questions for each other and want to interject, if there are no questions to off the bat, then feel free to do that. Are there any questions? Microphone.
So I'm certainly less well-versed in this than both of you are, but it's been my impression that when the redefining marriage issue has been put to a vote, the electorate seems to usually come out against it. And I noticed that aspect of it was kind of absent from both of your treatment. And obviously voters aren't perfect, and they've voted for some pretty dumb things over the years. But I wondered if you could comment on what relevance the will of the electorate has to this debate.
Well, I guess that's fundamentally the question. If this is a constitutionally protected right, then the will of the electorate is irrelevant. If you look at the time of Loving against Virginia, something in the high 90% of voters thought that anti-miscegenation laws were a good idea, or thought that black and white couples should not exist. That was not relevant to the decision there. So my view is the will of the electorate is not a relevant question when we're talking about a constitutional right.
Yeah, I think that's accurate, that if it were a constitutional right to have same-sex marriages, then the will of the electorate would be irrelevant. I don't think there is a constitutional right to redefine marriage. I think this is something that is up for popular discussion. It's changing a fundamental institution of civil society. It's changing a public policy and a fundamental institution where there's nothing in the Constitution itself that requires it be defined one way or the other. I see good policy arguments on both sides of this particular debate. Right now, there are 11 states that have redefined marriage democratically, which I think is another point to show that it's not a politically powerless group. This is being worked out by the states. Much better to avoid doing a Roe v. Wade of marriage. What the court did in the abortion debate was they short-circuited democracy. And as a result, the American political regime on the abortion issue is dysfunctional, and our laws are out of whack with the rest of the globe. Europe has much better abortion policy. It's neither fully pro-life nor is it fully pro-choice. They're able to work out compromises that we can't do because of some of these bad court rulings. I think we should avoid that on the issue of marriage policy.
Well, yes, maybe.
So, Mike,
oh, great.
I just wanted to point out that I feel like that was kind of a misquote of President Obama. I don't think that those statistics are going towards, I mean, I think that's more for single mothers raising children without a father. I don't think it speaks to lesbian couple raising 2 kids. I don't think the data will show that a lesbian couple raising 2 kids has those outcomes.
Sure, yeah, the quote that I read from President Obama is just about marriage in general. And so at that point, I was explaining what is the rational basis for marriage policy? What is it that gets the state in the marriage business? It's not because the state cares about your love life or my love life because it's a sucker for romance. Government's not in the marriage business because it cares about consenting adult love just as such. That what gets government in the marriage business is in a certain type of consenting adult relationship can produce children, and children deserve to be raised by a mother and father. And when this doesn't happen, various social costs run high. And I used the Obama quote just as a nice summary in terms of crime, graduation rates, teenage pregnancies, employment rates, things of that sort. So that if you want to kind of do the best you can to promote social justice, you would want to create a culture in which as many children as possible are raised by their married mother and father. It's 50 years ago this year that Senator Moynihan issued his famous report on the black family. 50 years ago, Moynihan's concern was that while births to single mothers in the general population were in single digits, births to single mothers in the African-American community were approaching 25%. And he thought that was going to spell disaster for social justice reasons for African-Americans. Today, births to single mothers for the general population is 40%. So 15% higher than what got Moynihan concerned. And it's 70% in the African-American community. Many scholars are saying this is the most urgent social justice issue of our day. Same-sex marriage didn't cause this. I want to get clear that my argument about marriage, that there are 2 different visions of what marriage is. There's one vision that says it's about a comprehensive union of sexually complementary spouses who live by monogamy, exclusivity, and permanency so that children that they help produce have moms and dads. There's another vision that I argue says it's just about consenting adult caregiving and romance. My argument is that many heterosexuals have bought into this vision of marriage and lived it out for the past 50 years, and that's what explains the rise of divorce and the rise of non-marital childbearing and the rise of various other social ills. My argument is that that vision of marriage is the one that would be enshrined in the Constitution if the Supreme Court were to say that the Constitution requires the redefinition of marriage. And that that vision of marriage will then make it much harder to combat those social ails that President Obama rightly highlighted. So if you do think that 70% of black kids growing up without their father is a social problem, how do we as a community insist that those fathers are essential when the laws redefined marriage to make fathers optional? That's the heart of my argument about why marriage policy matters.
So and I would just say to that, I think I completely agree that it's a good social policy and will lead to more stable families if children are raised by 2 parents in a committed, loving relationship. I just don't think that it has to be a man and a woman. And one of the reasons that it's so problematic that we don't recognize the marriages between same-sex couples is because a growing number of same-sex couples is adopting children. It's whether you're an adopted child being raised by a mother and a father or an adopted child being raised by a mother and a mother, you have the same, it's just as valuable to you to have the stability that comes from that committed family relationship as it is to the child that was created by the procreation of the man and the woman in the marriage. So this connection back to procreation, I think, distorts what's really at issue when we're talking about family stability and the need that kids have for that kind of family stability, which I completely agree with. And I don't think, by the way, that allowing gay people to get married is going to cause more fathers to leave.
Sure. So, I mean, let me clarify that part of the argument and then say something in response. The clarification is that the argument here is not that more fathers are going to leave because gays can get married. The argument here is that as we further continue enshrining a certain vision of marriage, the vision that came out of the sexual revolution in which consenting adults should do what consenting adults want to do, a vision of marriage that sees marriage primarily about adult romance and caregiving, and that disconnects it fundamentally from an institution that's ordered towards creating and then raising the next generation. That's what's going to impact people's understanding about marriage. It already is impacting people's understanding about marriage. We see this through no-fault divorce laws. We see this through various demographic trends with respect to marriage over the past 40 years. So that's the clarification of the argument I'm making. The response on the social science or on the parenting in general is that it's not simply stability. We know now from about 50 years of robust, random sampled, representative samples, longitudinal studies, that there are really three factors that explain why marriage matters for children. Stability is one of them, but the other two are biology and gender. We know that having a biological connection with the child matters for that child. We don't know all the reasons why, but we know that girls who are raised by their biological father as compared to a non-biological father go through puberty about a year later on average than other girls. There's something about the biological connection that delays the onset of puberty. We know that mothers hear the cry of their biological child more sensitively than they do for non-biological children. The scientists aren't yet sure about what all the pathways are, but we know that biology matters. And this is one reason why if you go into the hospital and you're pregnant, you care when you check out which baby they give you. You didn't just go in to get a child, you went in to get your child. And it matters both for the parents, but it also matters for the child. You see children now, there's this group called My Daddy's Name is Donor, combating anonymous sperm donations. There's a hunger, biology matters. So that's point one. Point two is we know that gender matters, that there's no such thing as parenting. There's mothering and there's fathering. That on average and for the most part, moms and dads interact with their children in discrete ways. And it's not because of gender roles or because of stereotyping that we say dads have to do this and moms have to do this. It's because this is what just comes naturally to fathers and what comes naturally to mothers. The social scientist shows that this appears in discrete and tangible ways, that when you look at the data, dads do certain things for their kids, moms do certain things for their kids. And this is why absentee fathers and not just two parents matter so much. It's that father does something for his daughter, that father does something for his son. Lastly, we know that stability matters, and what we know so far from the social science is that same-sex relationships tend to be less stable than opposite-sex relationships, not because they're homosexual, but just because of the distribution of the parties. That a female-female relationship is the shortest lived of the three. So you have male-male, female-female, and male-female. The female-female is the shortest lived, not because it's a lesbian relationship, but because it has two women involved. Women tend to file for somewhere between 2/3 and 3/4 of all of the divorce proceedings. Women tend to have a higher threshold for emotional intimacy. And so when you have a relationship with two women, on average and for the most part, it tends to last for a shorter amount of time than with two men or with a man and a woman. What we know about the male-male relationship is that it tends to be more fluid. Not because it's a gay relationship, but because it has two men. Men tend to be more sexually open, more sexually permissive. And so the social scientists show that when it's the man-man relationship, that's where you get the concept of the monogamish relationship. It's a two-person relationship, but sexually open. So I would argue that the stability aspect here, even in the same-sex relationships, will prove to be less stable than the male-female relationships.
Wow. So there was a lot there. I do have to say just one thing. There were two things I did for my children that my husband could not do. I carried them and I nursed them. Other than that, he can do everything I can do for them. And it minimizes the role of the father and minimizes the role of the mother to say that somehow the things they do are so unique that they have to do them. It essentializes men and women in ways that have consequences so far beyond what we're talking about today. They are terrifying to me as an employment discrimination scholar. And when we talk about what we know, that's one group of social scientists that has found those things. There are social scientists who have made other findings as well, and there's lots of science out there and social science out there that says being raised by a loving, committed, homosexual parenting group produces great, healthy kids.
So I just need to say one thing in response to that. I didn't say anything normative. I didn't say anything about how mothers should act or how fathers should act. I said something descriptive, that the social scientists report that this is how mothers do in fact act, and this is how fathers do in fact act. So I'm just saying the reality of this, whether you think it's a normative matter or not, it's irrelevant. This is how moms and dads interact with their kids. And I don't think it in any way detracts from that. I think it shows all the more important that each one is unique. Each one is bringing something unique and distinctive to the parenting enterprise. I don't think that in any way marginalizes their role. Professor Hart is entirely right. There is disputes about the social science, which I think is all the more reason to not rush into this one way or the other at the constitutional level. Allow the laboratories of the democracy to experiment, and we can then look back. When we're old and gray, I will either be proven right or proven wrong. We'll be able to look back and say what Ryan Anderson said was prophetic or he was an idiot. But if we constitutionalize and we stop the debate now, we won't be able to have that experience. We won't have the laboratories of democracy. And so since I see good social science on both sides, I'm inclined to not rush to a conclusion at the constitutional level.
One of the arguments that was made was that marriage is not something that was historically protected by the Constitution, or that the Constitution was silent on it in terms of whether it's between same sex or opposite sex. But what about the fact that constitutionally people who are, black people weren't considered to be people? In fact, they didn't have citizenship. They weren't considered to be at the same class as other people, and that has evolved. Either the Constitution is a living Constitution and it evolves, our interpretation of it evolves, or it doesn't. If it can evolve, why can't it evolve in this?
Sure, I mean, I agree. The Constitution is a living document and it can evolve when we, the people, amend it. And I think that the example that you point to precisely highlights that point. That the amendments that were passed precisely to enfranchise African Americans were the way in which we updated our Constitution to fix the flaws that were in it from the beginning. That's how I think constitutions are living, breathing documents. When we, the people, exercise our constitutional authority to amend them, to update them. I think the role of the judge is to apply the Constitution to the case before him or her. It's not the role of the judge to update the Constitution. It's the role of the judge to apply the Constitution, which is why the representatives and direct citizen votes are so important. So that we, the people, get to shape what our Constitution is, and then we elect or nominate, depending on the system, judges to then interpret and imply that Constitution.
I agree that the Constitution can change when we amend it. I think it's also true, and I think this comes back to sort of I think there's a real, I know there's a real debate about what originalism would say about the answer to this question about marriage equality. And again, the brief that Stephen Calabresi filed was really persuasive on this, that when the original meaning that we're looking at in this context is the original meaning of the 14th Amendment. We're talking about what was the purpose of this amendment. It's been argued increasingly, and Justice Scalia likes to say this, that the only purpose of this amendment was actually to address the inequality faced by the now freed slaves. Certainly that's an interpretation. I think when you look at the documents from the time in terms of contemporary discussion about what the Equal Protection Clause was doing, there's a lot of evidence of discussion about this desire to eliminate what they called caste laws that took one group, and whether any group. They didn't have discussions about homosexuals because they didn't have discussions about homosexuals, but to take one group and put it in an unequal position vis-a-vis the law. That's the idea of equal protection of the laws. And as we have looked at that being applied over time, and I think, what's interesting to me, the court is not going to be able to avoid, or they might. I think they'll actually have to cite Romer against Evans in this decision, which they generally try not to cite as much as possible. But in fact, the vision of equal protection that Justice Kennedy started to articulate in Romer against Evans, and that has been further developed in Lawrence and in Windsor, that focuses on the idea that you can't take one group of citizens and make them pariahs and put them in this completely different status in relationship to the law, is what the Equal Protection Clause is about. And if you look at the original meaning of the clause, that's what it was about, and that supports the view that you can't take gay men and lesbians and put them in a different relationship with regard to marriage and all the myriad benefits that the state uses marriage to mete out. And again, I think that's also an important point to think about when we think about what is the purpose of marriage. States and the federal government use marriage as a means to mete out so many different social benefits and to address so many different social policies that the notion that its only purpose is about responsible procreation, or rather irresponsible procreation, just doesn't make sense when you look at how marriage operates today.
I think that's accurate if the truth about marriage was that it was a genderless institution. So I agree that the 14th Amendment is supposed to provide for the equal protection of laws. And so if laws are not treating all citizens equally, then it would be legitimate for the courts to say this law violates the Equal Protection Clause. And that's exactly what the court did with the Loving decision. Looked at it more through the due process, fundamental rights, but you can say it's both to a certain extent. Part of that argument is that there is no plausible argument whatsoever that anyone could make that marriage has anything to do with race. There truly is no rational basis at all to anti-miscegenation laws. And so it was clear to say that what was going on here was that we were denying equal protection to interracial couples. I simply don't think that's the case when it comes to the male-female definition of marriage. A definition of marriage that's been witnessed throughout all of history across all of the globe up until 15 years ago. A radically different history than the history of bans on interracial marriage. And so that's why I think, provided that there are good arguments on both sides about whether marriage is inherently a sexually complementary union or is it inherently a genderless union, therefore it's not up for the judges to say which one of those visions is the truth. Because only if you say that marriage is a genderless institution can you say that a husband-wife definition of marriage violates equality. Because if the truth of the matter is, an ontological, metaphysical truth that marriage is a gendered institution, then it's not denying anyone equality before the law. That was the whole point of my opening of saying that in order to prove this point, my opponent would have to prove that the gendered understanding of marriage is simply false. And I don't think that we've achieved that conclusion from tonight, and I don't think it's going to be possible for the lawyers to do that before the Supreme Court. And the only other thing I would add is that marriage law has it's a sexually complementary union, it's also a monogamous, permanent, exclusive union. Do we want to say that our marriage laws deny equality to people who aspire to multi-person unions, or people who do aspire to temporary marriage licenses? The Washington Post has floated the idea of a wed lease instead of wedlock, a temporary marriage license. Or to people who want a sexually open marriage license rather than an exclusive communion. Only if you think that we defined monogamy, exclusivity, and permanency to exclude and denigrate polyamory and polygamous people, or people who want temporary unions, swingers rather than people who go in for the long haul, et cetera, et cetera. Only if you take that vision of it can you say that it's violating equality. But if you take the vision that marriage is something, it's a permanent, exclusive, monogamous union of a man and a woman, and that any citizen that wants to enter into that, the law treats equally, and any citizen that wants to enter into something else simply isn't interested in marriage. That's one of the arguments here. And you would have to say that that entire argument is irrational and has no plausibility whatsoever to conclude that it's an unconstitutional vision. And that's what I think can't be accomplished at the Supreme Court.
I just have a question about the point you were just making, and then a little broader question. You were saying that if we define marriage, only if we do not define marriage as a gendered institution, would we be able to prevent wed lease or multiple marriage or swingers. But as it stands today, if someone wants to have a temporary marriage, they can go get married and then they can go get divorced. If someone wants to get married and also have sex with other people, they can do that under the laws as it stands. So I'm just curious, if the definition of marriage is a gendered institution, then what is the alternative for people who choose to partner with the same gender? And whatever that alternative is, how is that not the separate but equal that we have moved beyond?
Great question. So let me say a couple things. So at one point, adultery would have been grounds for divorce with fault. At one point, adultery was illegal. Adultery was a crime. Whether or not we should go back to that is a whole other question. But it highlighted that the norm of exclusivity was attached to the marital relationship, and it could explain why. In the same way, marriage is still a permanent institution in the sense that you have to get divorced to make it a temporary institution. The idea of the wed lease is that when you went and got your marriage license, it would be a 5-year contract rather than a till death do us part contract. This argument in the Post was saying that marriage is a problem because we have this unrealistic expectation that it's supposed to be a permanent union, and then half of them end up failing and they get divorced. Much better have a realistic expectation that it'll just be 5 or 10 years. Sign up for a wed lease instead of a wedlock. The other point that I made was that what if you have 3 people who live with each other and love each other, they want to have a joint checking account, they want to visit each other in the hospital. Newsweek magazine reports that there are 500,000 households like that in the United States, that there are 500,000 polyamorous. I'm not talking about polygamy, I'm talking about polyamory households in the United States. The term that it goes by is the word throuple for a 3-person polyamorous household. On what basis would you deny them their fundamental right to marry? And it can't just be consent and administrative costs. Are you really saying that 3 people are unable of expressing consent? That seems paternalistic. Why can't 3 men consent to live with each other and love each other and care for each other? And then administrative costs, are you really going to deny someone a fundamental right because of administrative costs? That seems like a very low threshold. We can work out, I mean, whatever it was going to be, if it's a matter of inheritance, each surviving spouse gets that amount of the property divided by however many your surviving spouses. If you have 1 spouse, it's 1/1. If you have 2 spouses, it's 1/2. There would be ways of working this out if we really thought that marriage wasn't a monogamous institution. And so my point here is that saying that the reason that we're inclined to say that, oh, no, it would be too complicated to have thruples have their rights to marry, is that we don't actually think marriage is a plural institution. We think it's a monogamous union. My argument is that the reason that we have come to the conclusion that marriage is a monogamous, permanent, at least in hopes, and exclusive union is precisely because of the male-female part. It's precisely because a man and a woman can unite in an act that can create new life, and new life has 1 mother and 1 father, that we view marriage as a union of twosomes. Once you say the male-female part of marriage is irrational and arbitrary and bigoted, what is the basis for monogamy? What is the principle in law for limiting marriage to twosomes and only twosomes? And that's a question that I haven't heard persuasively answered. And so, I mean, we can open it to the floor. If people have it, I can turn it to you. I mean that would be part of my argument at the court. And I think Justice Sotomayor caught on to this when she was asking Ted Olson this same question. I think the Sixth Circuit highlighted this point as well. And I still think it's an unanswered question.
And I guess I would say I think that we can say that marriage is ideally exclusive, monogamous, and permanent, and still say that it is between only 2.
But why? I mean, I know we can say it, but my question is, do we have a justification for saying it? Because I think the justification for monogamy, exclusivity, and permanency is built upon the foundation of sexual complementarity. And so I think once you wash away the foundation of complementarity, you're left with a house of cards for the other marital norms. And that it's only a matter of time before the logic works itself out. The logic here is consent, and that marriage is just a consenting, loving, caregiving union. And so my question is, what are the constraints that you're going to place on the consent of the loving, caregiving relationship that wants to have their marriage rights recognized?
So we are running out of time, but thank you all for coming. I want to close with asking Professor Hart, you've tracked this issue and the case pretty closely. So you've kind of alluded to it, but what are your, I think oral arguments are April 28th. The decision will come out end of June, but kind of what do you suspect will happen? What's your prediction?
Well, so I hate making predictions about these things because I turn out to be wrong, and that irritates me, and especially if it's being recorded, that's just terrible. But I guess I think the court will say that states have to recognize validly entered marriages from other states, and I think that will be at 6-3. And I think the court will say that I think the court may not tell us yet which level of scrutiny it's applying, or it may actually apply heightened scrutiny, but that the court will say states have to recognize marriages between same-sex couples. And I think that will be either 6-3 or 5-4.
Great. Well, thank you all for coming. We do have a reception.
Oh,